tremendous turnout, and good afternoon, everyone. I'm Leslie Stein, Director of the Government Law Center at Albany Law School, and I would like to welcome you all to the first program of the 2022 Warren M. Anderson series. I would also like to thank our program sponsors, Whiteman, Osterman and Hanna, Greenberg Traurig, Harris Beach, and Hinman Straub. The mission of the Government Law Center is to help state and local governments better serve their communities through nonpartisan legal research and analysis. By bringing together a diverse and inclusive group of lawyers, students, scholars, and community partners, we prepare students for careers as skilled and leading attorneys in public service, advance Albany Law School's unique connection to government, and inform nationwide conversations on government and the law. This year marks the 30th anniversary of the Anderson series. We have a distinguished panel of speakers today on the important topic of government ethics reform. Our moderator will be Richard Rifkin, Legal Director of the Government Law Center. Richard has worked in New York State government for over 40 years and is an expert in government ethics. He has served the executive branch as special counsel to a former governor and in various positions in the Attorney General's office. He has also served as the executive director of the New York State Ethics Commission. I will now turn the program over to Richard.
Thank you, Judge Stein. Good afternoon, everyone, and welcome to our first Anderson program of this legislative session. We have three outstanding panelists this afternoon, and they'll be discussing an issue that has received more than its fair share of attention. Before I start, let me remind everyone who wishes CLE credit for this program to submit their affidavit of attendance and also their evaluation form. We need that if you're going to get your CLE credit, so please remember. At the outset of this program, I would urge you to put aside much of what you have probably read in the media about JCOPE and ethics. So much of it is dealt with the politics of ethics enforcement, often examining who appointed a particular commissioner, who took a particular position on a matter when there was a difference of opinion at a meeting. Ethics regulation is a complex topic, and we will get into many of its aspects in our discussion this afternoon. The structure of any commission that regulates ethics is obviously very important, but so are subjects like voting requirements at commission meetings, transparency, including the application of the Freedom of Information Law and the Open Meetings Law, commission responsibilities for the financial disclosure statements that it receives from those who are required to file these statements, training those who are subject to ethics regulation, and offering advice when needed by officers and employees who have questions. These are all issues that arise when considering changes in the state's ethics regulatory structure. Our speakers today will examine these issues. Seth Agata was the executive director of JCOPE, and he'll be explaining the state's history and current practices in the area of ethics regulation. Elizabeth Fine is counsel to Governor Hochul, and she will give us a summary of the proposal that the governor has submitted to the legislature and which is now being considered as an Article 7 bill. Evan Davis is the manager of the Committee to Reform the State Constitution, and by the way, was counsel to former Governor Mario Cuomo. And he will present an alternative proposal to the governor's, a proposal which would amend the Constitution rather than make legislative changes. I'm not going to give you extensive bios this morning in introducing each of the speakers. They are contained in the materials that you have. Finally, let me say this is a 1-hour program, but we may run over for a few minutes if there are questions. Please put any question or for any or all of the speakers in the chat box, and we'll get to as many as we can as time allows. That's what I have to say. So let me introduce Seth Agata and ask Seth to open our discussion.
Thank you very much, Richard, and thank you, Judge Stein, for having me. This is something it's fun to speak about for me, and just pleased to be here with Evan and Liz, who are two truly outstanding attorneys. So it should be a good discussion. Let me start with something totally unoriginal. In the beginning, I stole that line from another source. How did we get to where we are today with JCOPE? And are we really in that bad a spot? Looking back at ethics reform, and it's always been reform because it's always reactive. Something happens, government reacts, it does something, circumstances change, government reacts again. Briefly, going back to the Cleary administration, post-Watergate, no commission, executive order regulating executive branch, certain executive branch employees. Very limited. Mario Cuomo comes in, Therick Commission, a more substantial state ethics commission, a formal commission is established, not by executive order. Separate commission dealing with lobbying, and the lobbying regulation goes back a bit further, but you had executive ethics on one side, separate lobbying on the other, and off as well, separate legislative ethics regulation. Scandals, reaction. Eliot Spitzer comes in. Under the Spitzer administration, and through another reform, and this is sort of the evolution of where we're going. Separate ethics, separate lobbying. He merges ethics and lobbying into a single commission. Legislature still out there. JCOPE, Commission on Public Integrity, is formed. You have a commission that has oversight of executive employees, executive members, all the way up to the governor, with legislative appointees. So you have legislative appointees regulating the executive, but still the legislature is off on its own. Governor Patterson comes in, proposes a merger, a single unified body in a program bill. Not taken up by the legislature. Ultimately, legislature beefs up substantially the legislative portion of regulation and the executive as well. Bill vetoed. You end up with Governor Cuomo, Cuomo 2. The mandate, and having been and worked with other attorneys on both sides, on all three sides, but the mandate from the governor was he wanted to do the one thing that every reform group wanted in terms of ethics regulation, and that was a unified ethics regulatory body. That's where joint comes from, the Joint Commission on Public Ethics. And it was truly a joint commission. But to get the legislature, and this is it's inherent in our Constitution. And I think Evan's proposals, we'll talk about it later, actually help address some of that. But there's this tension between the legislative and the executive branch, and the legislative branch exceedingly reluctant to have the executive look into their court. And added to this sort of dynamic between the different branches of government is a political dynamic. You had a Senate majority at that point, fairly narrow, Republican majority in danger of shrinking, looking at Democratic control of the Assembly, all the state offices, and very concerned about a lack of bipartisanship, or really more a concern about the overuse of partisanship in ethics regulation. So ultimately, a compromise is sought, and that's what we're that's the body that we have now. Revolutionary in New York terms, in terms of having a single body with oversight of the legislature and the executive, conducting investigations of both, but there were certain compromises made. One is that you read about. I don't want to use a law French word. It's very fakak the voting. There's a voting mechanism that tried to maintain a balance between Democrats and Republicans, and the fear that this entity would be a tool for partisan repression, and a concern that the executive would overreach with the legislature. And once the legislature had been given that authority, greater authority perhaps, to look at the executive, there were concerns on the executive standpoint that the legislature would overreach. So a balance was trying to be achieved. And that's how we have what some of the good government groups and what have you have called veto. It's a requirement that, depending on the political party and the branch of the individual being investigated and ultimately found to have violated something, there has to be a certain number of individuals from that person who are sharing the characteristics of that person. Same political party, and if the person's from the executive branch, has to be an executive appointee. Not unanimity on the part of the executive going after an executive branch employee, or the legislature going after a legislative employee, but in the case of the executive, for example, 2 out of 3, 2 out of 3, so it need not be unanimous. Similar appointment structure in the appointment of the executive director. And the other part of that balancing act was giving the legislature the ability to and recognizing their institutional prerogatives to impose a punishment on its members and to accept the findings of the legislative of JCOPE. JCOPE investigates, makes findings, sends it to the LEC for final disposition. I think when looking at that, you realize that JCOPE is simply the latest iteration of this evolving trend towards centralizing and in some respect, getting more oversight. I think, in fact, getting more oversight over ethics in both branches of government, but it's also part of a larger larger movement that took place when JCOPE, and part of these compromises that took place. Part of that structure included increased source of funding disclosure, which the Brennan Center at the time said was, and in fact, is the first in the country to look at how money finances lobbying. And that's been expanded upon over the years. Extensive financial disclosure, ultimately over the last 2 or 3 years, or more than that really, client disclosure, dollar amount disclosure, expansion of what is lobbying, ultimately defining what a gift is in more practical terms, but also bringing in and covering more conduct that might constitute an improper gift for lobbying. Part of this deal that was reached involved the state's first pension forfeiture statute, article, whatever it was, 3 something of the Retirement and Social Security Law, independent expenditures and super PACs, ultimately extensive campaign finance reform and independent and generally dealing with those issues. There were always issues. There were always proposals dealing with public finance reform. That was ultimately picked up on recently, but those were all part of the mix when JCOPE was created. What are the results? Beginning in about 2013, when JCOPE got its sea legs going, you had the investigation of former Assemblyman Vito Lopez. And since that time, numerous investigations of legislative employees and legislators, which might not have come to surface without it. I think a lot of the credit goes to the Legislative Ethics Commission, because there has been a respect of the LEC's institutional and the legislature's institutional prerogatives. But taking the Vito Lopez matter as an example, unanimous report on how to deal with him. The LEC adopts the report and imposes $300,000 more in fines. So that has been a working relationship. on a more mundane, but I think on a much more practical level, what JCOPE does outside of those marquee type matters, as Richard pointed to, is deal with the 99.9% of state employees who are covered by the law, offering guidance on a daily basis. I can't even imagine the number of guidance letters and emails and conversations there have been by a very, very dedicated staff. There are, by statute, random reviews of lobbying reports and targeted and random reviews of financial disclosure statements that have gotten very complicated. That's what gets done on a broad level, on a daily level. And as people who are in the enforcement business and in the government business know, is that good employees want to follow, good public officials follow codes. The ones that aren't so good don't follow them, no matter what one does, but one can certainly set up guideposts and enforcement mechanisms. Ultimately, I think the way JCOPE has operated it can be improved. This was the first step forward to have this joint regulation of public ethics, which has been sort of the lodestar of reform groups, and I think even going back to the FERA Commission. And it's probably ready for a next step. Things can always be improved, but it succeeded. Ready, and it's nothing is perfect, nothing is enshrined in stone, and I think it's ready for its next iteration, if there should be one. So that's about it, Richard.
Thank you, Seth. And what you've done, I think, is demonstrated what I had said, that ethics regulation is complicated. It is not simple at all. Before we go on to the next speaker, I'd like to remind everybody that in a program like this, there is a code word. And our code word for this session is reform. And when you submit your papers, please remember to include that code word, reform. Thank you very much. And with that, let me move on to our next speaker. Seth has sort of brought us up to date from the start of all of this years ago to where we are today. And now take a look at some of the changes that are being proposed. Our next speaker is the counsel to Governor Hochul, Elizabeth Fine. As I mentioned, there is a bill pending in the legislature that's been submitted by the governor, proposes reforms in a good number of the areas that Seth touched on. She will lay them out for us, explain to us what is being proposed, why they're being proposed. So with that introduction, Liz, you're up.
Great, thank you so much. It's such a pleasure to be here. This is one of my favorite topics, I can imagine. And I want to thank the Law Center and the Warren Anderson Seminar for including me. I am very happy to talk about this issue, which has consumed me for many years. So I like to start at the 30,000 foot level a little bit. And, I started my career in government on the House Judiciary Committee before there were really any guidelines on what people could and could not accept. And I was a counsel to the House Judiciary Subcommittee on Courts, Intellectual Property, and the Administration of Justice. So I had the pleasure of having both prisons and patents in my portfolio, and I got to see a real difference between a subject like prisons, which really didn't have any lobbyists, and patents, and later copyrights and trademarks. And it was like the holidays every day in our office, because there was so much financial interest in patents and copyrights and trademarks. We were awash with chocolates. we were flooded with invitations to movie openings, concerts, lunches and dinners, excursions. We were invited on trips. It was just, you would not have to, make any social plan if you wanted to just live the life of that staffer who took advantage of all of that, and also of for the members as well. And, it was a real eye opener for me at the time. And I was so concerned, not just that the financial interests were going to, help influence the outcome of a decision in Congress, but I was concerned even more deeply at the time that the financial interests were actually setting the agenda for Congress and deciding how Congress would spend their time. And when you talk about conflicts of interest and ethics, what's so important and what's so fundamental is that people in the public be able to know and trust that their elected officials and people in government are working not to protect their own personal interests, not to protect somebody else's private interests, but to always protect the public interest and always in the public interest, whether it's awarding a contract in response to an RFP, whether it's deciding to build a bridge, or whether it's taking, a position on legislation. And so when we talk about having a functioning ethics entity in New York, an ethics watchdog and oversight board in New York, it's about ensuring that New Yorkers have trust in government and know that we are doing our jobs to protect them and to advance their interests and not our own. So that's key. Then I also think that it's important when we have our ethics, an independent ethics entity, that and create laws, that we not create them in such a burdensome way that you isolate members of the government, employees and elected officials, that you keep them from interacting with people in the public, because we have to be in touch with the public and with the needs of people in order to do our jobs. And you don't want to have them so burdensome that you discourage people from going into government. So we're always trying to maintain that high level balance and reach those goals, ultimately to provide the best service for the people of New York. So that's my framework here. And I don't know, I would love to hear, Richard and Seth and Evans, they may have a different framework, but that's how I approach it. So I was very happy to come work for Governor Hochul, because she is committed in the highest way to transparency, integrity, and integrity in government. She made that clear day one. She was very clear that she wanted to build a respectful workplace where people treated each other with compassion and respect, and that people acted with the highest level of integrity. And also she's committed to a high level of transparency. And she took a number of steps right away to achieve those goals. She sent a directive to the heads of all state agencies, directing them to identify transparency measures, to respond more in a more fulsome and expedited way to FOILs, and to find ways to make their work more accessible to the public. She sent a memo and made a video for all state employees talking about what her expectation is for the workplace. And she's required all chamber employees and everyone throughout the government to have live harassment and discrimination training, and to require ethics training. Right now, as many of you know, ethics training is required for many people in state government, but not everyone, and we're going to change that. So one of her big goals from day one was also to replace JCOPE, which has done a great job, but it has shown that there is some room for improvement, as Seth noted, and replace it with an entity. And I think the emphasis before was on joint, and now the emphasis today is on independent. independent, removed from politics, because I think we've seen in the last year or more that sometimes the politics and sometimes of the rules that enabled that legislation to be passed have also made it very difficult to function. So one key goal has been to have an independent entity that has a simplified governance structure and provides excellent customer service for people throughout government, great training, clear enforcement, and one of our main goals has been to effectuate this as quickly as we can. So you'll hear from Evan Davis after I go through what we're doing about some more aspirational ideas, and they are excellent ideas. I think one thing we decided was we didn't want to bite off more than we could chew. We want to see what we can get done now and have a functioning ethics entity today. So we started to put together a proposal. And to do this, we met with many of the advocates in the community who have been instrumental, have been very thoughtful about coming up with reasonable, practical ways to set up an ethics entity in New York State. And we also turned to the Government Law Center at Albany Law School. And thank you to the Albany Law Center for doing excellent work and doing nationwide research on many different issues. I have my memo, what is the jurisdiction of the commission? They looked at the jurisdiction of ethics commissions around the country. How many members should the commission have? Who should serve on the commission? What's the disciplinary authority? What are the procedures for such a commission? Does the commission provide guidance? And how are these commissions created in other states? And this proved invaluable. So I hope it's the beginning of a long partnership with the Government Law Center, because we incorporated a lot of the thought in that research into our proposal. And we also met with experts. We worked with Evan and Reinvent Albany and Common Cause and NYPIRG and the bar associations, all provided great input. So what did we end up doing? So how do you create an independent commission? You have to start with independent appointees, and you have to get away from the idea that elected officials are going to appoint the members of the commission. And that raises a question of who out there in New York could make the appointments. And the governor came up with the concept of having the law school deans make the appointments. And it was a very innovative and interesting idea. It took a little time for us to explain and massage the idea, but where we ended up, and this is one of the key elements of this proposal, is that there are actually 15 law schools in New York State. And the benefit of the law schools is they are throughout New York State. They're in New York City, Long Island, Buffalo, Syracuse, and right in the capital. And the deans and Ithaca, I would not want to forget Ithaca. And I may have forgotten one more, but if I did, I apologize. But they're throughout Westchester. They're throughout the state. And the law school deans are, they may be political, they may not. And so the idea was to have them be the appointing authority. Well, how many people should there be on a commission? We want it to be workable, so we settled on 5 members of the commission. And who should they be, and how should the law school deans pick these people? I think there was some concern that the law school deans sitting in their ivory towers were going to pick some highfalutin professors who were out of touch with New Yorkers. So we wrote into the proposal, and I think we're still working on that a little bit, some criteria. We really want the law school deans to get together and pick people of diverse backgrounds, from communities across the state with different kinds of experiences that they would bring to bear. We have, limits on who could serve because we don't want people who are lobbyists who are currently in government to serve. And we have some restrictions on who could serve, but the idea is we want to reflect the diversity of New York on the commission. We will have 5 members. They will serve for, I think we ended up with 4-year terms that will be staggered. So you'll have a continuity of expertise on the commission. And I'll just mention a couple of other key things, and then I'm going to turn it over to Evan, who can talk about the aspiration. But we left intact the concept that Seth described of having the legislative commission deal with all of the enforcement for members of the legislature. And the reason we did that is because if we changed that, we would need a constitutional amendment. And that goes back to the idea that I said at the beginning, that we wanted to be sure that we could get this done as quickly as possible. And, I don't want to say, don't let perfect be the enemy of the good, because I think this is pretty great, but we want to get something done. And then, so we have 5 members. And then when we talk about governance, Seth referenced the governance challenges right now with the special vote that many of you are familiar with. We took that out, and we have the commission will act purely by majority vote. They have clear authority to delegate to staff. They will have to comply with the open meetings law and FOIL requirements. They're no longer exempt from FOIL. And we have mandatory training for all employees of the state, live, I believe it's live mandatory training, and I like it to be interactive. I don't know if any of you have ever seen that participated in the training that the City Conflicts of Interest Board does. Alex Kipp is their director of training, and he's just, I learned ethics from him in the city, and he's just so entertaining that there's some real value in just making it so entertaining. And then the last thing I'll say is that, we are trying to set it up in a transparent way. We're asking and requiring that more of the information be made available, that the hearings be public after there's a probable cause determination, and that the commission have an annual meeting, and this was a suggestion of the good government groups, an annual meeting for input from the public. And that's an opportunity once a year to hear from the public about the operations and about recommendations. So I will end it right there. I've given you an overview, and I look forward to questions and conversation. Thank you.
Thank you very much, Liz. And I think we got a pretty good idea of the governor's, beyond the bill, her thinking on this, which I think is quite important, and her objectives in submitting this bill, why she submitted the bill, and some of the issues in the bill. It's funny, one of the issues brought me back to my time as the executive director of the first Ethics Commission, established by an act in 1987, when there was a reporter, whenever he mentioned the commission, he always preceded the name of the commission by the word super secret. And that's been something that has been within the commissions for all those years, and at least the governor has a proposal to deal with that. So our final speaker, and I think Liz has pretty well explained that there are differences, although she obviously respects what Evan is doing. Evan Davis. Evan is going to explain to us his number one, why he's putting into the Constitution, and number two, the provisions that he would propose in the Constitution if he were successful in getting a constitutional amendment adopted. So with that, Evan, the floor is yours.
So with the other good government groups, we formulated a constitutional amendment, which we called the Anti-Corruption Amendment. And we called it that because we believe that good, strong ethics enforcement is the first line of defense against corruption. When you get to corruption, you're dealing with people who have definitely crossed the line. But ethics enforcement keeps people on the safe side of the line. That's a very important thing to do. So our amendment has the support of 40 members, co-sponsors in the Senate, which is a majority of the Senate, a significant majority of the Senate, both Republican and Democratic members. And we have almost 50 in the Assembly. Not quite as impressive as the Senate, but not insignificant. So there is significant support in the legislature for the proposal. Having said that, I have to be candid. And one of the reasons we had a constitutional amendment, when it's a true fact that much can be done by statute, there are very few things like abolishing the LEC that have to have a constitutional amendment. But much can be done by statute, but a statute has to be signed by the governor. And a constitutional amendment does not have to be signed by the governor. It's effectively signed by the people in a referendum. And we saw getting the kind of real reform that we thought was necessary as facing another obstacle if Governor Andrew Cuomo had to sign the bill. Now the world has changed. And I want to emphasize how thrilled all the good government groups are, and I am, and everybody who's worried about this issue, with the fact that Governor Hochul has come up with a very big, significant ethics reform proposal. I think it deserves the title, that elusive title, Real Ethics Reform. And it does very important things that can be done by statute. And I'm going to highlight, some of the things that we would still like to see be done in the statute that add a few extra protections. But it's a really significant change from what we faced before, when we felt the need to go directly to the people because the governor would not be supportive. So someone told me that the magic question is, what would it take? So I'm going to ask 3 magic questions with regard to ethics reform. And the first is, what does it take to create an appointment process that results in a truly independent commission that in both perception and fact will act without fear or favor? And we have to remember here that in New York State, we've had a problem with corruption at the highest levels, leadership levels, statewide elected official level. And because of that, the body must be sufficiently independent, act without fear or favor, even when the governor is involved, or the speaker is involved, or the majority leader of the Senate is involved. And that's a high bar, because you have to have folks who really will stand up for the law and not be afraid of the person. And what we have now doesn't meet that test at all. I mean, one interesting little piece of evidence is what happened when Julie Garcia voted in a way that Andrew Cuomo didn't like. He called up the speaker and complained to the speaker about what his appointee had done. What does that tell us? That tells us that the attitude is that these are the appointees are the people of the people who appoint them, and that they are accountable for how they vote. That's totally not the way it's supposed to be. No one should ever think of calling up the speaker to complain about how the speaker's appointee voted. But that, unfortunately, is what happened. So in the Constitution, we proposed that a majority of the members be appointed by people who are not regulated by the commission. which we looked at the judiciary, and a minority could be appointed by the governor and the legislature. Now, Governor Hochul's proposal is that everyone will be appointed by deans. And I think that's just great. That is a wonderful way to get at independence, very effective, a big step forward. Will the legislature agree? Will they want to appoint some members of the legislature? As I say, our proposal would have allowed that. We'll have to see. But what Governor Hochul has proposed is great. And it would provide that independence. If you do go to a system where you let legislators make appointments, I think it's very important, and the other groups do too, the good government groups, that the appointments be joint appointments, meaning, for example, that the Democratic leader in the Assembly, the Speaker, and the Democratic leader in the Senate, the Majority Leader, make one appointment between them. If they can't agree in 30 days, you flip a coin and that decides who gets to make the appointment. That'd be a strong incentive to them doing it jointly. And the advantage of jointly is that there can be no sense that this commissioner belongs to a particular individual. So the next question is, what does it take to give the commission the necessary enforcement tools? So we proposed in the Constitution that just like the bar that governs lawyers, where you can be disciplined with everything from an admonition to a disbarment, we think that the commission, the State Ethics Commission, should also have that direct disciplinary power, which it does not have now, to issue censure, warning, and the like. And not in the executive branch, this would be done directly. In the legislative branch, since we're not abolishing the LEC because we don't have the constitutional amendment to give us the authority to do so, it would be a recommendation to the LEC. But that censure discipline power is very, very important to effective enforcement. We also all believe strongly that the state code should have an amendment to make it the duty of every state employee to report known misconduct. And I emphasize the word known, because we don't want to make this too broad, a duty susceptible to second guessing. But this is what the standard is for lawyers. As you lawyers know, you have a duty to report known misconduct by a fellow member of the bar. Right now, there's a duty to report to the IG, but that is totally ineffective. I mean, going back to Julie Garcia for a minute, how can it be that after all these months, we still don't know who leaked the information to the governor? That should be the easiest thing in the world to figure out. But the IG was supposed to investigate it. Seth asked him, in accordance with the statute, to do that, and it was a joke. And the IG reports to the secretary of the governor is not independent. You know, the commission should have the exclusive jurisdiction, and the report should be to the commission. And the final, what does it take question? What does it take to convince the public that the commission is doing a good job in actual practice? I was really glad to hear Liz say just now that the hearings will be open after a finding of probable cause, because that had not been entirely clear to me when I read the proposal. I think that's very, very important. So consider what these hearings should be like. I think it was a mistake not to give, for example, Governor Cuomo a hearing on the issue of use of state people to help write his book. There should have been a hearing. And because there was probable cause to think there'd been a violation, there should have been a public hearing. And the commission instead said, well, we revoke our approval and now you can get the $5 million back, I think there has to be a due process hearing, but it should be public. And there should be reporting. In general, the goal should be the maximum transparency possible. So if we could make these few additional changes that would really strengthen it, it would meet the question of what does it take, then we could really celebrate a full solution. I know that's hard to achieve, but it's never wrong to try. Thank you.
Thank you, Evan. I'd like to put a question to the three panelists, and then we'll get to audience questions in a moment. But one of the things that I've been kicking around in my own mind is whether this is better done by statute or by a constitutional amendment. Seems to me the advantage of the statute, let me say, given the history of that Seth went through for us, we have never quite gotten this right. And, you know, the hope is we will get it right this time, but there may or may not be the need for amendments to whatever is done here and whatever changes are made. If it's a legislative act, of course, the legislature can change it. That means it's easier to change, but it can get enmeshed in the politics of the state. If you do it by constitutional amendment, it becomes much harder to change. But in the end, you, as Evan pointed out, if you've got a resistant governor, you can get by the governor and have it approved by the people. And we just saw that issue with regard to the Independent Redistricting Commission when the legislature proposed an amendment to a commission established by the Constitution, and it was voted down by the people. So I just wonder what the speakers think of doing this by legislation or by constitutional amendment. And whoever wants is welcome to go.
I'll say, for what it's worth, Richard,
Yeah.
I guess I share the same concern. Every 10 years, we have something that happens in New York State that says we can build a better mousetrap. And no matter what criticisms there are of JCOPE, and some of them on the voting mechanisms are valid. We've always, I guess this is, you know, in history, they call it the Whiggish view of history. Things always get better. Things have been taking progressive steps in the legislative front in terms of building a better ethics commission. And it is less responsive and it can be less flexible and less responsive to needs. I think it's a certain amount of hubris to think that whatever way we reshuffle the cards and come up with a new deck of players on an ethics commission, that's going to be, you know, that's the ultimate. It's proven not to be the ultimate. There are criticisms of JCOPE, there were criticisms of COPE. So I think if you enshrine it in the Constitution, you've now stifled evolution. Actually, in the specific proposal, you actually put I love state bar presidents, by the way. They're great people. Some of my best friends are state bar presidents, but you've enshrined them as constitutional officers to remove politics as the goal has been, or you'll have law deans to remove politics from the selection process, which I don't think is necessarily healthy because it shows a distrust of democracy. But however you're going to do it, if you enshrine it in a constitution, to undo it is a terrible, it's a terrible burden. So I count on us doing better each time. And you kind of make that a lot more difficult by putting the latest iteration of our ethics regulation in the Constitution.
So
Go ahead, Evan.
the Commission on Judicial Conduct, which has been very successful, much more successful in my judgment than JCOPE by many miles, is in the Constitution. I agree that for this year, the focus should certainly be on a statute. But it's important to amend the Constitution at some point so that we can make the right decision about the role of the LEC without regard to the separation of powers and speech and debate problem. And right now we can't because the Constitution decides it. There may be a role, as in the Commission on Judicial Nomination, where the judges are in a minority. The judicial appointees are in a minority. There may be a role for having judges appoint members of the Ethics Commission. We can't do that. As I read the excellent opinion about the appointment method for the Commission on Prosecutorial Misconduct, really well-written opinion, and it left me persuaded that that would be a real risk, that would not work. But that could be fixed in the Constitution. So I think there are things, and another thing we could do, and I'm sure Seth would like this one, is we could put a more guaranteed funding stream for JCOPE into the, we have constitutional mechanisms to do that. We do
Amen
it for
to
the
that.
legislative budget. We do it for the judiciary budget. I think it's worth doing it for the JCOPE budget or the new entity budget, because starving the entity is another way to remove its effectiveness.
Thank you, Evan. Liz, any thoughts or you want to?
I was just going to say, as a very practical matter for us, we feel the urgency of now. And that, you know, steers you directly towards a statutory approach as opposed to a constitutional approach, because we would have to have a constitutional amendment passed in 2 successive legislative sessions and then go to the voters for approval. So we wouldn't actually see any reform for quite some time. And I think, you know, as somebody who spent many years in government and really my whole career, I'm sort of embarrassed to say, I've spent, you know, many years, and right now, I have always appreciated having a ethics body that I can have on speed dial, both for myself and so that I can advise the agency and individuals what they can and cannot do, and have that open relationship. And I think that right now there's a concern about the, you know, whether we can do that with the current functioning of JCOPE, and because of the partly because of the partisan nature. And I want to say that JCOPE has such a professional, expert staff. They have nothing but well thought through, statutorily based reasoning and advice to provide. But they, I think, are somewhat limited in what they can do because they have a board that wants to act as a board and is limited in what they can do, and is limited in what they've delegated to the staff. And what we really need in government is that agency on speed dial that we can call all the time. What do you think about this? And, you know, issuing regular guidance and opinions, and that's going to help the functioning of government. And the only way we can get to that place quickly is with a statute.
Thank you all. Let me say we have less than 5 minutes left for the hour. The speakers have agreed that they're willing to stay for a few minutes after the hour to answer audience questions. But if anyone in the audience has to leave at 1 o'clock, you will have earned your CLE credit. So you were welcome to leave. But we're going to see if we can take up some of the questions from the audience. For that, I would ask our deputy director at the Government Law Center, Patrick Woods, who's been following the chat, to lay out the questions that we have from the audience. So Patrick.
Hi, so I've got a few questions in the queue here. The first one that came in I'm just going to read it. So it's the opinion of the questioner. It does not appear that the proposed legislation alters the current financial disclosure questionnaire, the specific questions of which are unfortunately set forth in statute. The current questions are complicated and often result in erroneous responses, incomplete responses, or excessive disclosures. Is there any consideration to having those disclosure questions reformed as well? Simplification and clarity would benefit the filers as well as the public in understanding them.
Anybody want to take a crack at that from our speakers?
I'll take a stab only because I was there for 2 negotiations that created part of the mess. So let me tell you how we got there. And I couldn't agree with the speaker or the questioner more. It can be a lot easier. And maybe this will happen if we have a different structure to ethics enforcement. It is a politically loaded document. Questionnaires at the federal level are not part of statute. They are regulations, and they go through a regulatory process. In New York, because of concerns actually arising in the negotiations about client disclosure, which not so much people in the executive, but in the legislative, because they are part-time legislators in terms of disclosing clients, how much money money they're being paid, who they're representing. It is a terrible document. And it should be simplified. There should be a way of doing it. I think there was too much distrust to delegate it to some kind of regulatory body under SAPA, because there's a distrust because it applies to the legislature, to the executive. But perhaps if any of the independent mechanisms that either Evan or Liz have mentioned become, maybe that'll give that the credibility, and maybe they'll have the regulatory authority to do that. It will require a statutory change, but the statute is abysmal. There's no doubt about it.
I would just note that's when I talk about having our ethics laws not make government employment or participation on a board too burdensome so as to deter people from joining government service. That's the kind of thing I'm talking about. It's very hard to change, though. Those financial disclosure laws are so specific. There's not a lot of flexibility in what can be reported, and they're very hard to change because, as Seth noted, they were very carefully negotiated. So I would say this on that issue. I agree with Seth 100% that this new entity with some independence could have the credibility to propose some changes to that and other aspects of the law. And this proposal that we have is not the be all and end all of ethics reform and improvement of ethics in government. This is the first step. And there's a lot of proposals that ethics that Evan and the other good government groups have made that are highly worthy of consideration. And we want to continue that conversation. But this is what we hope to achieve now. And we hope that the legislature will agree to adopt the proposal that we have put forth.
Evan, any thoughts on this one? You may not.
Well, I feel a little guilty because back in 1987, I negotiated the first form of the financial disclosure statement. One thing that sticks in my mind is the legislature wanted it not to be a violation to put in too high a number, which I thought was really funny. But anyway, that's what the law is now. Certainly it can be improved. Certainly it should be improved.
I'll just add one
I
other
think
thing.
that a new commission is likely to make significant suggestions to the legislature. And I think the legislature is more in a mood to follow them than it was back in 1987.
I'll just add that I share in the guilt because I was involved in the negotiations as well. Next question.
One I have is, does the governor's bill or the proposed constitutional amendment make the financial disclosure filings and other ethical rules apply to the legislature members and to the judiciary?
So not to the judiciary, because they have their own system of disclosure and recusal, which is commanded by the judicial ethics rules. And they have a very strict rule of recusal, much stricter than we would apply to the legislature. But they do apply, the financial disclosure does certainly apply to the legislature and to the executive branch.
Yeah.
Richard, if I'll just bring up one other thing about financial disclosure. It's a curious thing, and maybe this goes back to you and Evan in the original financial disclosure. Is that if you, and it's certainly something that can be fixed, and it's one of the kind of problems with lack of enforcement of the ethics laws. If you file a false financial disclosure statement, the worst thing that can happen is that JCOPE, or whatever the entity happens to be, and the way the law reads, can go after you. But you're filing a false instrument, and it's a very high standard. I think it's knowing and it might be knowing and intentional. If I'm an individual who files something with the county clerk, I've now created a penal law misdemeanor. But the exclusive way of prosecuting someone for intentionally filing a false financial disclosure is the violation of that financial disclosure statute. And it's up to JCOPE or the entity to refer it to a prosecutor. So it's a terribly burdensome document. The violation law associated with it are marginal. So there's some tinkering that can be done.
Yeah, I remember when we negotiated the original law, the idea was to give the ethics entity the power to impose basically civil fines for violation of the ethics law. And if it saw criminality based upon the evidence that it had, its obligation was to refer to the district attorney. Anyone else? Or we should go to the next question. Next question.
If the entire state workforce is going to be expected to take ethics classes or programs, who is going to be tasked with implementing and keeping track of that training? It would be a lot of work for each agency to have to do that in addition to their daily work.
Well, again, I would just say everyone here who's a lawyer has to keep track of their CLA training. And it's a pain, but you have to do it because you have to certify every 2 years that you've done the CLE training. So I don't think it's an insuperable problem.
And I would just add to that, that there are other required trainings for state employees on harassment and discrimination, on workplace safety issues. There's a whole host of trainings. The big change here is that it's not going to be that everyone's going to have the ethics training, and it's not going to be a click through training. Click, 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 click. I've memorized the online trainings at this point, and I could click through it in 5 minutes. But that's going to be the key. We already have mechanisms in place, and we will make sure that agencies, together with this new independent ethics commission, have the resources they need to do quality training and to keep track of it and to ensure that everybody gets trained. It's not going to have to be for everybody the same training that you have as a policymaker or a required financial disclosure filer. It can be adjusted so that it's a broad training so everybody grasps the key concepts, that you're doing your job for New Yorkers and you cannot use your position for personal gain. It doesn't have to be a 2-hour training. There's some key principles. They have to be well articulated, and we have to show people with examples, because there's a lot of nuances involved in how you apply the principles, but it's going to be available and required for everybody.
I read a training manual put together by JCOPE, and I thought the hypotheticals were excellent, really good hypotheticals.
I always felt, whenever I give a presentation on ethics, my view is that state officers and employees have to know enough about ethics so that they recognize a problem if it arises in their work. If they recognize the problem, they can go get advice on what to do. Recognize the problem, they could be in deep trouble.
Absolutely, and have a place to go that's available all hours to get that advice.
Let's see, we have time. Let's try one more question and then we'll let everybody go.
I will read this one verbatim and then provide slight spin of my own. Will there be anything about sending corrupt politicians to jail and term limits? My slight spin on that would be what mechanisms are we talking about in terms of criminal enforcement? Is the proposal to have the newly revamped commission have prosecutorial power, or to still have a referral method to other state prosecutors?
So the referral, it's a referral still in both proposals. A broader referral, though, it could include the Attorney General, where the Attorney General has appropriate jurisdiction. In the constitutional amendment, it could even include a federal prosecutor if a federal statute had been violated. But no, not direct prosecutorial authority. And as far as sending corrupt politicians to jail, I mean, this has been so sad. Isn't it really sad that Shelley Silver died in jail? I mean, that was a tragedy. And good ethics enforcement can keep that from happening because it nips these things in the bud. It's really important.
I would just add that the governor did propose a constitutional amendment to restrict the 3 statewide elected officials to 2 terms in office. And that would be the governor, the attorney general, and the state controller. And so we'll see if that constitutional proposal proceeds, if there's support in the legislature for that.
I'm just add just a couple of comments just about, the enforcement and the criminality. Right now, the way the law is written, and there are no changes to the law, so those ethics laws aren't changed. It is, as I said, for those of us who have practiced criminal law, the burden of proof is knowing and intentional in some and knowing and willful. It's harder to even establish the civil violation than it is to establish the criminal violation when you have to prove something beyond a reasonable doubt. So that the laws themselves, even establishing, and I can tell you from an administrative standpoint, looking at a civil violation, the bar is such that it's difficult. And when one finds that there is a criminal violation, from my experience, referring it to a prosecutor, I think the DAs are very, are willing. They say, oh, we don't want to do, people say they don't want to do misdemeanors. Well, public officer law violations that are misdemeanors, first of all, when they do arise, do involve a certain expenditure of assets that a lot of local and smaller district attorney offices and even larger ones don't have. I think one thing, if one is going to put some teeth into the enforcement, is to perhaps set up some kind of public integrity enforcement fund where DAs can, at least get some backfills and have an incentive to go in and enforce the rare times that there are criminal referrals. And there are really no limits on those criminal referrals. I think the teeth that Evans and actually Senator Kruger's bill has, authorizing more direct punishment by JCOPE, such as censure and other, is a great idea. And that kind of takes out that prosecutorial aspect. There are some immediate consequences that can flow. But unless you actually rewrite some of the laws, the real ethics laws, the ones that this new entity is going to enforce and make them stronger, and put a little money, and as Evan said, put money behind it, I think there's a certain a certain weakness that's present in the current structure.
I think we're going to have to call it quits. It's getting on. We have to let the speakers go. I'm sure many of you have to get back to your work. So let me conclude by thanking the speakers. I thought this was a very informative program, at least for me, and I hope it was for the members of the audience. We'll conclude at this point, and we'll be back with our second program on the Law Revision Commission. An announcement about that will be going out shortly. So again, thank you to everybody, and I hope everybody who is listening found it informative.
Thank you so much. Thank you.
Thank you, everybody.
And thank
Everyone
you,
take
Judge
care.
Stein. And I hope anybody who has suggestions for us will be in touch with us.
Thank you all. It was terrific.